what we say to America is be true to what you said on paper. If I lived in China or even Russia or any totalitarian country, maybe I could understand some of these illegal injunctions. Maybe I could understand the denial of certain basic First Amendment privileges because they haven't committed themselves to that over there. But somewhere I read of the freedom of assembly. Somewhere I read of the freedom of speech. Somewhere I read of the freedom of press. Somewhere I read that the greatness of America is the right to protest far right.
Despite constitutional guarantees, American civil rights and liberties are constantly in danger of violation, whether by individuals, corporations, or government institutions. Regardless of whether personal prejudices or national security concerns lie at the root of these violations, challenging them and holding wrongdoers accountable is imperative for the sake of the constitutional integrity and the preservation of the American way. Trial lawyers advocate for awareness, the truth, and a person's right to know. They believe that in the absence of the truth, all of us stand helpless to defend ourselves, our families, our health, and our way of life. Oftentimes, we don't think about or worry about or understand what is happening to another until it happens to us. Deceits have no boundaries. Disease doesn't recognize the color of our skin or our political party's affiliation. When it comes to cover-ups and false allegations by agencies of the state and the federal government, there is not a soul amongst us who does not have a cringing fear of their overwhelming, awesome power. It is at these times that we need experienced and dedicated trial lawyers, the warriors in the courtroom, who are willing to battle for us tooth and nail in the halls of justice to protect our cherished way of life. In this Insider exclusive Investigative Network TV special, our news team goes behind the headlines in Seattle, Washington, with Jay Krulewitch, Michael Kolker, and Leonard Feldman to get the inside story of a landmark case won against the Seattle Police Department in Justice in America, Andrew Rutherford's story. The importance of this case validated an important public interest for citizens to be free from unlawful detentions committed by police is guaranteed under the Fourth Amendment of the United States Constitution. That Andrew obtained only $1 in damages does not diminish the fact he vindicated his constitutional rights. Because of this victory, Andrew was permitted to seek and obtain reasonable attorney's fees and costs incurred in successfully prosecuting this matter. Congress expressly authorized every successful litigant who defends constitutional rights pursuant to 42 United States Code Section 1983 to seek attorney's fees and costs in order to ensure that the federal rights are adequately enforced. It would be difficult to imagine a statute more clearly designed for the public good and to prevent injury and wrong than Section 1983. As two of Andrew's trial attorneys, Jay Krulewitch and Michael Kolker, have stated, not all victories are huge victories, but sometimes even the smallest victories for our clients can have lasting effects and serve to educate the powers that be that there are limitations to the exercise of their authority over others. Justice comes in all shapes and sizes. And nowhere is there more dramatic proof of that statement than the case of Andrew Rutherford versus Jason McKissick, where an award of nominal damages has taught the Seattle Police Department that there are limitations as to how they can conduct investigatory stops and what kind of force they are entitled to use when detaining occupants of a vehicle pursuant to a traffic stop involving minor misdemeanor offenses. The importance of the case grew exponentially, significantly after the City of Seattle appealed and lost before the Ninth Circuit Court of Appeals, and then sought review before the United States Supreme Court, where it was declined for review. The Honorable Chief U.S. District Judge wrote in her original decision, It is a sad day when the Seattle Police Department cannot stop to reflect upon the voices of citizen jurors who think that their conduct has overstepped the line or contemplate a change when an officer's judgment is found wanting. It should be a marker laid down to police officers that their authority is not absolute, and before deadly force is used or displayed to gain compliance with their orders, they must recognize that citizens hold precious rights given to them by the Constitution that cannot be breached. The problem of police brutality is much more widespread than most Americans are willing to admit. Our nation practices a selective blindness. In this great and strong nation, we have all become unwitting accomplices to that continuation of the conflict. Jay Krulewitch, Michael Kolker, and Leonard Feldman have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in Seattle, in Washington, and across the nation. They have seen many innocent and hardworking people become victims of police brutality. They understand that police brutality is one of the most serious, enduring, and divisive human rights violations in the United States. The problem is not just in Washington, but nationwide, and its nature is institutionalized. And because of that, they are driven to fight for people who have been harmed by the willful or negligent actions of others. They learned a long time ago that if a man hasn't discovered something he will die for, he isn't fit to live. Their goals? Not only to get justice for their clients, but to make sure all Americans have the right to a fair trial, honest cops, impartial prosecutors, and fair judges with no agendas. Because injustice anywhere is a threat to justice everywhere, and justice and power must be brought together so that whatever is just may be powerful, and whatever is powerful may be just. This is the Insider Exclusive, live from Seattle, Washington. It is my great pleasure to introduce Jay and Michael to the show. Welcome to the show, guys.
Thank you.
Thank you.
Today we're in Seattle. We're discussing a very important case that deals with civil rights. Tell our audience a little bit about your practices, because both of you handle those kind of cases, don't you?
Yes. We do criminal defense,
Yeah.
civil rights, and personal injury.
Right. And you've been at this, Jay, for how many years?
Well, been a trial lawyer for over 26, been in my own private practice for over 19 years.
Yeah.
So I've been handling civil rights cases for pretty much the entire time I've been out in private practice, 19 years.
Now, a lot of people call your offices and they make complaints against the police, and this is kind of an exceptional case. When Andrew contacted you first, right?
Yes.
When he contacted you and told you his story, what were your initial thoughts?
This is absolutely bizarre, absolutely crazy, outrageous.
Yeah. And what were your steps after that?
Well, he initially was charged with a criminal offense.
As the police normally do, don't they?
Yes.
If they know they made a mistake, oftentimes they'll charge you with an offense thinking they can use that as leverage so you don't sue them, right?
Well, they charged Andrew with obstruction, and obstruction is usually the charge that the police will file when they can't really think of anything else to charge somebody with,
right,
to justify their actions.
The problem in this situation is it fit a profile that Michael and I had seen over and over again, where there was no substantial underlying charge.
Mm-hmm.
That the charge of obstructing, like resisting arrest, is kind of an add-on charge.
Yeah.
Nobody gets usually arrested for those kinds of charges. That's usually in addition to an underlying charge, and there was no underlying charge here.
Yeah. This was basically a road rage case, wasn't it?
Yes.
By an off-duty Seattle police officer.
Jonathan Chin.
Who used his powers to try and wreak havoc in somebody's life, right?
Well, that was our argument to the jury, that
Yeah.
it was basically a road rage case involving an off-duty police officer at 2 in the morning.
Now, initially in your lawsuit, you made two claims. One, excessive force, correct? And another one, Which was?
We actually made 5 claims.
5 claims. Tell us those claims.
We made claims for an unreasonable seizure. We made a claim for excessive force. And then we had 3 pending state law claims. We claimed assault and battery. We claimed false arrest, false imprisonment. We also claimed malicious prosecution. And 1 claim got through.
And which claim was that, by the way?
Well, the most important claim, actually, it was the constitutional claim. The jury found that Andrew's rights, Fourth Amendment rights, were violated. In its essence, it was a Terry stop violation, an unlawful investigatory detention. And it was a violation of the U.S. Constitution. It was a very important violation that they found.
Right. How difficult is it to prove cases like this?
I would say extremely difficult.
And why?
Well, often cases in this area are filed in state court and then they're removed to federal court. And that's a different jury panel. It's a different environment. It wasn't a problem for Michael and I because we're used to federal court, but for a lot of lawyers that could be a problem because a lot of lawyers are very comfortable in state court and not so comfortable in federal court, and they know that. And they remove the case to try and take the case out of your comfort zone.
Right.
That's one thing. The jury panel is also different. And then you got the interlay of federal law, federal jurisprudence under Section 1983. That makes it more difficult, more complex. You have to know what you're doing, and you have to know federal civil procedure, which is different than state court. It's different than the procedure in state court.
Right. As we are speaking, we're showing some pictures, some photographs of what happened to your client, Andrew, and some of the head injuries he suffered. So my first impression when I saw this was, hey, this is excessive force, right? Why didn't that make it through?
Well, it's really hard to climb into the mind of the jury and figure out why they didn't come back in excessive force. We were certainly disappointed. We thought we made a good showing in the trial court.
Right.
We put on the evidence for them. We had the medical evidence. We even had a doctor from Harborview talk about her treatment of Andrew for a concussion syndrome. But for whatever reason, they decided not to go with excessive force. But they did find that that Jonathan Chin, a Seattle police officer, violated his constitutional rights under the Fourth Amendment.
And in cases like this, they come back with an award.
Well, in this case, they came back with $0. They did not come back with an award. But we made a motion right after the verdict was announced to have the judge consider awarding Andrew $1 because every constitutional violation at the very least is deserving of $1.
Right.
And she took that motion that we made right there orally after the verdict under advisement, and then later ultimately ended up granting that motion and gave him $1 and corrected the jury's oversight in that regard.
What is the significance of this entire case, and why do lawyers like yourself take on these constitutional issues to protect society?
Well, the Fourth Amendment is the most important amendment that we have. I mean, the Fourth Amendment protects us all from unreasonable seizures by the police. The Fourth Amendment says that before the police can take out a gun and seize you at gunpoint, they have to have probable cause. And our argument in this case was that Andrew was the passenger in the vehicle. He hadn't committed any crime. He hadn't done anything wrong. The officer didn't know who was driving, and even the only crime he had witnessed was reckless driving, which is certainly not a violent crime or a felony. And despite that, he took out his gun, pointed it at 3 individuals, and ordered them to sit in the street at gunpoint at 2 in the morning. They didn't know he was an officer. They didn't know they didn't understand what was happening. They thought they were about to be murdered. And Andrew, who was the passenger in the vehicle, had not committed any crime. The basic rule of Fourth Amendment law is that probable cause has to be individual. You can't just point a gun at someone because you're not sure what crime has been committed, or you don't know what you've observed.
Right.
So our argument was that this violated Andrew's rights to be free from unlawful detention, and the jury agreed with us.
Right. Now, the city of Seattle spent a lot of money trying to appeal this case, didn't they?
Over $700,000.
Over $700,000. Once the $1 verdict had been announced, they spent in excess of another, $250,000 appealing the case.
They spent quite a bit of money trying to fight that decision.
Why was that so important?
They wanted to initially supposedly save the reputation of Officer Jonathan Chin.
Yes.
That's what they communicated to us. But as the appeal went forward, and as you'll talk to Leonard Feldman about, their focus changed. Their focus changed to trying to overturn a very important case in Ninth Circuit jurisprudence called Washington versus Lambert. And Lambert really, in essence, limits the police in their ability to pull a firearm during the most common police interaction we know, which is a misdemeanor traffic stop. And Lambert limits their ability to do that. They wanted Lambert thrown out. They were going to use our case to get to Lambert, and that was the reason that they went to the U.S. Supreme Court to try and get the U.S. Supreme Court to take review.
Right. We have Leonard with us today, so let's bring him on so he can discuss the appellate level of this. It is my great pleasure to introduce Leonard Feldman to the show. Welcome to the show, Leonard.
Thank you.
You're an appellate lawyer, right?
I am, that's correct.
And you are called upon by trial lawyers like Jay, like Michael, once in a while, to handle cases when they go up to the appellate court. And in this case, it went to the Ninth Circuit, correct?
That's right.
What is the difference, and what is the strategies you use, and the difference between what an appellate lawyer does and a trial lawyer?
Well, the gift that trial lawyers have, including folks like Jay and Mike, is the ability to talk to the jury. And that's the art that they focus on, and it's their strength. And primarily what they're talking about when they're having this conversation with the jury, through the witnesses, of course, is what are the facts of the case. And so that's really their strength, is dealing with the facts of the case. Typically, when the issue gets to the Court of Appeals, the focus has shifted from the facts to the law. And it isn't purely legal. There's a factual underlay in all legal issues. But that's where the appellate lawyers come in, is that we focus more and we research more carefully what is the law and what cases govern a particular appeal. And then depending on our focus, whether we're trying to affirm or ask the Court of Appeals to affirm or ask the court to reverse, we bring the facts in to support our arguments.
And that is also the way you present this to your audience, which are jurists. These are people that are not as moved as normal everyday citizens emotionally, right?
Well, they focus more, again, on the law than the facts. So if you're representing the party that's appealing, you want to say to those jurists, this is a pure legal issue. You should get involved because that's your strength, that's your focus, and you should reverse. And that, of course, is what the city of Seattle did in this case. When you represent an appellee, you're typically saying, no, this isn't a legal issue. This is a factual issue. It was driven by the facts, and you, the Court of Appeals, should defer to the jury, and you should affirm.
Well, Jay, let me ask you this question. In this case, you had one cop, dark street, right? 3 young kids. We'll meet Andrew here in a minute. But you had 3 young kids, and they posed no danger. They had no weapons. What was the point of the officer pulling his gun?
Well, I think, he hesitated. He had pulled partly behind that vehicle by Mew Thant's house. I mean, they were taking the rear passenger home. They had been videotaping all day. He didn't know that, but that's what they were doing. They had a lawful right to take the rear passenger home. He claimed that he was investigating the driver for driving under the influence or reckless driving. But that would never apply to Andrew because he was the passenger. So for him to pull a gun and order all 3 young men into the middle of the street at gunpoint based on a express need, he said, to freeze the scene, just didn't fly. It didn't make any sense to us. It didn't make sense to us then. It doesn't make sense to us now. He had no right to freeze the scene. He had a right to investigate the driver, but not all 3 people. So just because he was in jeans and a t-shirt doesn't mean he can't act as an officer. We all know that they have the power to act as an officer 24/7. But he would have probably been smarter to call in a uniformed officer to come and take over the investigation and not try and handle it himself. And he put everybody at risk by his actions.
One final question. In all of the cases that you handled that involve civil rights, this is a pretty significant case, isn't it?
It is. And I've done a lot of civil rights cases. That's typically when I get involved.
my caseload in terms of the clients that I represent tend to be commercial clients. A lot of the work that I do, though, is pro bono, where we don't charge the client, and those are cases where it has to be an important constitutional right, or it's not something that I typically would get involved in, and this was definitely up there.
Well, I want to thank you for getting involved, because I know you work for a major corporate law firm, and thank God they have these provisions, pro bono work. And I want to thank both of you for being on this show, because this is a significant case. Most policemen are, you know, good performing officers, you know, and thank God they're out there. But there are some bad apples, and when there are bad apples out there, we have to go to cases like this. And thank you very much for sharing your case. Thank you.
You're welcome.
It is my great pleasure to introduce Andrew Rutherford to the show. Welcome to the show.
Thank you.
You have been through hell and back, haven't you?
Yes.
Never expected to be pulled over and made to sit in the middle of the street and had a gun pulled on you?
No, that was totally unexpected.
Yeah. What did you initially think when this happened? What was it, 2 o'clock in the morning?
Yeah, I was pretty confused, and
Did the guy show his badge?
no.
He did not.
He
Just
didn't
pulled
show
a gun on you?
Yes.
That's it?
Yeah.
He said he was a police officer.
Right.
What was going through your mind?
I thought at first we were getting robbed, and I was relieved to see actual police driving towards the scene after.
Right. Now, you got up out of the street because you were afraid that you might be run over, right?
Correct, yeah.
And you went over to the curb. You were tackled by another officer?
Yeah, there was a few officers that took me down.
And what did they say to you when they tackled you?
They were just telling me to get down and get down, get down, get down.
But you were severely injured.
Well, they threw me against the ground, and that's what caused the injury to my head.
And I understand you became unconscious, is that right?
Briefly, yeah. There was the main officer was well over 250 pounds, and he was basically like sitting on my head.
Now, you have never been involved with a lawsuit, have you?
Never.
In your life? No. So what made you decide that you wanted to make sure that this officer was held accountable and the Seattle Police Department wouldn't condone something like this?
Well, my biggest motivation was to cover my medical bills. They gave me an option to either go to jail or go to the hospital, and so I chose to go to the hospital, and was left with a hefty hospital bill, and so that was my main motivation.
Okay, and initially they wouldn't pay it, is that right?
Right. They then only when they wouldn't pay it, they didn't agree to settle the case. And, they didn't want to settle this case, and we had to sue them.
And they charged you with some misdemeanor,
Obstruction.
Right? Obstruction. And that eventually was dismissed, correct?
The obstructing charge was dismissed.
As a result of your experience, when you were stopped by a police officer now, what do you do differently?
Well, it's definitely wrecked my emotions towards cops. I try to just be very honest and open and not do anything so sudden. Since it's happened, I've probably gotten pulled over a few times, and it definitely makes me nervous, but I know that every person is different and whatnots. But
well, I'm glad you're better, and we really appreciate you being on the show. Thank you very much.
Thanks.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.